So I'll start with, I didn't allude to the fact that there are specific legal rights that shareholders have, and I would like to highlight some of these rights. The first one is economic rights. So basically, when you talk of economic rights, we're talking about the right to receive a distribution from the company's profits, and the right to sell all or part of your interest in the company. These constitute economic rights. So shareholders invest in companies primarily for economic gain. And basically, there are two ways in which shareholders can profit from the company, which is by receiving a distribution from the company or selling part or all of their interest in the company. So, however, it's important to note that when we talk about receiving distribution from the company, we're basically looking at the right to receive a dividend. And it's also important to note that this is somehow limited in the sense that shareholders only have a right to receive such dividends as they are declared by the company's board of directors. The directors may decide not to declare a dividend and reinvest the company's profits rather than distribute them to the shareholders. So it's important to take note of that point. Therefore, shareholders only have a legal right to the payment of dividend after they've been declared by the board. The other benefit, the economic benefit that I mentioned is the right to sell all or part of your shareholders' interest in the company. One of the key characteristics of companies is the right to transfer your shares, which means the right for you to sell those shares. So shareholders can sell all or part of their shareholdings and profit from that. And the profit in the sense that you can buy a share at a low price and come and sell it later at a higher price through what we call capital appreciation. For example, if you look at, if I give an example of, we've noticed in the recent past how the market cap for the Lucy has grown. I think as of 24th of December, the market cap stood at 329 billion. This is all attributed to the increase in the share prices. If I pick up one stock like Airtel, which is now selling at 137 kwacha, looking at Airtel last year, it was about 43 kwacha. So imagine if I sell it today, I could make a huge capital gains. So that's one of the ways in which shareholders benefit, and this is attributed to their economic rights that they have. The second right that I want to touch on is the control rights. And here, basically, we're talking about the separation of ownership and control. One of the key characteristics of companies is the separation of ownership and control. Although shareholders may own the company, they do not have the right to manage the business, particularly for public listed companies. That authority to manage the business is basically invested in the board of directors. Nonetheless, it would be wrong to conclude that the shareholders have no control rights. They do, in the sense that shareholders have the right to vote on important company matters relating to the business, which gives them some form of control over the company. The next legal right that I want to speak to is the right to receive information. And basically, these rights are derived mainly from the securities law, as opposed to some of the other pieces of law like the Companies Act. Shareholders of public listed entities get the bulk of their rights to information from the securities laws. In this case, we're talking about the Securities Act of 2016, as amended by by Act number 21 of 2022, and the subsidiary legislation. The Securities Act and the subsidiary legislation really creates or elaborates the framework of ongoing obligations about every aspect of the company's business. So, armed with this information, shareholders are empowered to protect their economic and control rights that I alluded to earlier on. If I may just cite one of the provisions in the Securities Act, which is Section 811, it says that an issuer, once securities are registered, keep the public informed of all matters which affect the value of securities immediately on their becoming known to the issuer by placing an advertisement in a newspaper of general circulation in the Republic or other media approved by the Commission, and shall submit reports to the Commission and the Securities Exchange on which these securities are quoted. So basically, this provision compels issuers or listed or public listed entities to provide information to the shareholders, so that shareholders can make an informed decision based on that information that the shareholders are receiving. We can move to the next slide. So the last specific right that I wanted to speak about is the litigation rights. If you recall, under the control rights, I did allude to the separation of ownership and control as one of the key characteristics of companies. So in that regard, shareholders have a fiduciary obligation that they need to uphold. And if you look at the Companies Act, that's under Section 106, it spells out the fiduciary duties of directors of companies. They have a duty to exercise directors' powers in accordance with the Act, duty to promote the success of the company, duty to exercise independent judgment, and duty to disclose information about directors' remuneration in the financial statements. If we go on to Section 7, also talks about the duty to avoid conflict of interest. So if directors do breach these duties, shareholders can sue on behalf of the company against the directors for breach of these fiduciary duties and any company mismanagement. So in a nutshell, these are the specific rights that I wanted to highlight before I move on to the broader rights of shareholders. I won't look at, there are so many rights, but I just selected a few that I thought would be important to highlight. So the first one is basically the right to attend general meetings. Now, general meetings come in two forms. There's an annual general meeting and an extraordinary general meeting. So the shareholders use annual general meetings to basically obtain information about the company and basically to question the directors in terms of how they've run the company. Remember, the shareholders are the owners of the company. So when it comes to annual general meetings, every company must hold an annual general meeting or once a year. Shareholders names which are on the register have the right to attend the such AGMs, and they must be sent a notice of the meeting at least 21 days before the date fixed for the general meeting. And essentially, the rationale behind the 21 days is basically to give ample time for the shareholders to look at the documentation that will be sent relating to the meeting, for example, the financials, so that they can ask relevant questions at the AGM. So the notice period is 21 days. However, if you look at the Companies if you look at the Securities Act, it's actually states 14 days. But since the 21 days in the Companies Act is in the main law, and the 14 days is in our the subsidiary legislation, so normally companies will follow the 21 days notice. So the notice of the general meeting should specify basically the day, the time, and the place. Although generally in recent times, we have a hybrid of these meetings. We have it physically and virtually. So in a nutshell, annual general meetings usually discuss specific business that needs to be discussed at that meeting. Usually, the usual business conducted with respect to annual general meeting is the consideration and approval of annual financial statements. Sorry, the consideration and approval of financial statements and annual reports. The directors lay before the company the annual accounts and reports for the most recent financial period for consideration by the members. The other business that's conducted at an AGM is the declaration of the dividend. Directors will recommend a dividend to be paid to the shareholders, and that will be voted on by the shareholders. There's also the business of the consideration of the directors and auditors report. This is basically the approval of the directors and the auditors report on the audited financial statements. Then there's the election of directors in place of those that are retiring. The articles may provide that directors are to retire in rotation. Some directors will retire at the AGM and may be reappointed or replaced. There's also the business of fixing the remuneration of the directors. Resolutions will be passed that will require the pay for the directors to be approved. And lastly, the appointment of directors, the appointment of the auditors and the fixing of their remunerations. Basically, the auditor's term of office ends at AGM, so they must be reappointed or new auditors must be appointed and fixing their remuneration. We can go to next slide, Sally. So when we talk of an extraordinary general meeting, basically these are meetings. These are general meetings which consider urgent matters that cannot wait until the next AGM. An example would be if there's a merger or an acquisition that has to be approved by the shareholders, and EGM may be called for rather than wait for the next AGM if that matter is really pressing and urgent. Another example would be disposal of a subsidiary that may call for an agent that may call for an extraordinary general meeting. And usually the extraordinary general meetings are requisitioned by the directors or any person in accordance with the company's articles of association. And similarly, in terms of the notice period is similar to AGM, which is about 21 days. Stan, we can move to the next slide, please. So the other right that I want to highlight is the right to receive a dividend, although I briefly touched on this earlier. I did allude to this in my preamble when I talked about the economic rights. As a shareholder, you have the right to a share in the company's earnings. This is what they call a dividend, and a share in the net profits that is distributed to shareholders in proportion to the shareholders' holding. So the directors, the board of directors recommends the dividend and submits the same to the shareholders for approval in the general meeting. Now, it's important for shareholders to note that there are three important dates that they need to understand. There's what is called the declaration date. There's what is called the record date, and the payment date. So basically, on the declaration date, the board of directors resolved to pay a certain amount of dividend in cash, and it is paid to those shareholders holding the company's shares on a specific date, and that's the record date. And on the date of payment, the company issues the dividend payment. The next right that I want to highlight is basically the right to offer of shares by the company at the time of further issue of securities, which is the preemptive right. A preemptive right is basically a contractual right to acquire certain shares newly coming into existence before they are offered to someone else or another entity. From time to time, a company may wish to issue further or raise further capital, have a preemptive right to participate. This is where the company asks existing shareholders if they want to buy new shares in the company in proportion to the existing shareholding held by each shareholder. Basically, what the preemptive right attempts to do is to ensure that the existing shareholders are not diluted when there's a new issuance of the securities registration rules. There's a clause that speaks to preemptive rights of shareholders. And similarly, if you look at the Companies Act in Section 144, they have a similar provision that speaks to preemptive rights. So if you look at what's in the Securities Act, it basically states that directors are required to get above the allot or issue or grant shares to anyone who is not a shareholder. Yeah, so they need to get that approval because existing shareholders have preemptive rights. The next right that I want to speak to is the right to vote. Shareholders are asked by the company to vote on important matters which affect the company. So basically, shareholders need to carefully consider the decisions to be shareholder as votes in proportion to their paid up capital, or in proportion to their
Okay, Mr. Bruce has fallen off. I will continue until he comes in. So he was speaking of the right to vote. So usually, right to vote is exercised at an annual general meeting where Oh, okay, he's back. You can go ahead, Mr. Bruce.
I'm just waiting for my presentation to come off the screen. Thank you. So the next right I want to touch on is the right to appoint a proxy. The shareholders can cast their votes personally at a meeting. However, any shareholder entitled to attend and vote at a meeting can appoint another person as his proxy to attend and vote in his place. Such a proxy shall have the right to attend and voting at a meeting as available to the shareholder. However, it's important to note that the notice of meeting must specify the shareholder's right to appoint a proxy and the rights of such a proxy as to attend the meeting and vote. So therefore, in a nutshell, a proxy form must be accompany the notice that is sent out for the meeting. Then there's the right to appoint and remove auditors. Auditors are external accountants appointed by the company to check the company's financial statements. The auditors, usually the directors appoint the first auditor or auditors within 90 days of a company being incorporated, who are going to hold the office until the close of the company's first annual general meeting. Thereafter, shareholders at each AGM must appoint the auditor. And actually, if the company fails to appoint an auditor within 90 days after the end of the financial year, the directors are actually committing an offense and are liable to conviction or to a fine not exceeding 150,000 fiat. That's according to the company's act. So shareholders do appoint and remove directors. So in terms of the right to elect and remove directors, shareholders have the right to elect directors. The shareholders, as owners of the company, elected directors to run their business on their behalf, and they hold them accountable for those acts. Like I mentioned earlier on, the first directors are usually appointed by virtue of the articles of association or otherwise. Usually all the subscribers at that time would be directors of the company, and will definitely hold the office until the first AGM is held. Subsequent directors will need to be elected at the AGM of the company for a period specified according to the company's articles of association. So in terms of the directors, a public company is required to have, by law, have a minimum of 3 directors. However, the articles of association of a company may specify a higher number than the minimum of the 3 directors. Equally, the shareholders can remove a director from office and by an ordinary resolution passed at a general meeting of that company. Then we have the right to receive or obtain copies of annual reports. Every company is required to send copies of annual accounts to shareholders. This is in terms of public listed companies, required to send copies of annual accounts to shareholders at least 21 days before at which they'll be laid before the general meeting. And this basically starts to give ample time to the shareholders to go through the accounts, like I mentioned earlier on. Then there's the right to information about the company. Shareholders make decisions regarding their investments based on information. Therefore, shareholders have the right to receive information that helps them make an informed decision. This particularly is the case for most public listed companies, where the information is vital in deciding whether me as a shareholder should hold or sell my shares. Earlier on, I did allude to the provision in the Securities Act, Section 81, that compels issuers to provide information to shareholders so that they can make an informed decision. Then there is right to residue assets at the time of winding up. Winding up a company refers to the process whereby all the affairs of the company are wound up, all assets are realized, its liabilities paid off, and if there's anything left, it's distributed to the shareholders in proportion to their shareholding. But you need to remember that the shareholders are the owners of the company, therefore they will be last in the queue to be paid after everyone has been paid. However, they still have this basic right to receive their residue assets if at any time the companies wind up in proportion to their holding in the company. So we can move to the last slide. So on this last slide, basically, I just want to highlight as much as they have those rights, they also have responsibilities. And the first one is basic to monitor the conduct of the directors. And as owners of the company, they need to monitor the conduct of directors in order to protect their long-term economic interests. Then they have also a responsibility to exercise their voting rights. Shareholders need to exercise their voting right by casting thoughtfully and informatively their votes that basically safeguards their financial and other interests at AGMs and EGMs. Then they also have the responsibility to ensure that the directors, management are performing their duties in the best interest of the shareholders. It's important that shareholders always keep a watchful eye on the affairs of a company and ensure that management is acting and performing its duties in the best interest of the shareholders. And lastly, they have the responsibility to promote also corporate governance. I think shareholders should promote more effective corporate governance in the companies, and ensure that the corporate governance practices meet high standards of accountability, transparency, and the fiduciary responsibilities of directors. Next slide, Stanley. And that's the end of my presentation. Apologies for the hiccups that we experienced. I had some challenges with my connectivity.
Okay, thank you so much, Mr. Bruce. And apologies to our listeners. And we'll go straight into our question and answer session. It was a very insightful presentation, I must say. And one thing that stood out for me was the right to vote, which also is which also turns into a responsibility in that you need to exercise that right to vote as a shareholder. Yeah. So we'll open up our floor to take up a few questions. We'll just spend about 5 to 10 minutes just to take some questions. I know people are in the spirit of closing their week to start their weekend, but we do appreciate you staying with us up to this time. Okay. Okay, so we have a few questions, Mr. Bruce. The first one is from an anonymous attendee who's asking, what is the meaning of fiduciary? Fiduciary. If you could just explain that a little bit more. I know you did touch on it in your presentation.
In layman's terms, the best way I can define it is it's a duty where you take the best interest of the other party. I think that's the best way that I can explain it. Maybe I can give an example of I don't know whether the person who's asking the question is familiar with the agency theory, where if I apply the agency theory, the company is the principal and the directors are the agents. So the principal, being the owner of the company, I employ the directors, the agents to run my company. They need to run the company in my best interest. So they've got that duty to act in the best interest of the principal. Those are the fiduciary duties that I mentioned. And if you look at the Companies Act, some of those duties have been listed.
Okay, we have another comment.
For example,
from
director needs to think independently in the best interest of the company.
Okay, thank you for that response, Mr. Bruce. I hope that explains it, and I hope our attendee who asked the question has gotten the response. We have another one from Mr. Stumbeko, who wants you to explain a little bit more about majority and minority shareholders. I think he means the difference between the two. What is the difference between a majority shareholder and a minority shareholder?
So if I hold, okay, I look at it from different angles. Under the Companies Act, if I hold 51% and the others hold 49, like collectively, the party or the person holding 51% is the majority shareholder because they control the company. They've got more than 50%. So that's a majority. If you look at the Securities Act, there's a slightly different angle. There's when you look at the mergers and takeovers rules, basically we speak to 35%. Anyone holding 35% is assumed to have some form of control. So therefore, if I acquire extra shares, I'll be compelled to make a mandatory offer to the remaining minority shareholders. So it depends on from which angle you're looking at the majority shareholder and minority shareholder. If you look at the CCPC, they've all got their own way of looking at who's the majority shareholder and minority. So it depends on at which angle you're looking at this. But basically, it's a person who is holding the control in a company. That's the majority shareholder.
Okay. Thank you for that, Mr. Bruce. We have
so in our case, it's control in terms of.
Sorry, please go ahead. You can just finish your point.
Now, I was about to say, if you look at this from the Securities Act point of view, we're looking at who's got control in terms of the voting rights. Can you proceed, Stanley?
Okay. So the next question is from Chalwe Moape. I would like to know the right, for you to explain the right to residue assets at the time of winding up, what that means. He says he didn't get it quite clearly. You did mention in your presentation about the right to residue assets at the time of winding up.
Yeah, as I mentioned in my presentation, shareholders are the owners of the company. So if anything has to shut down or a liquidator is appointed, the shareholders, being the owners of a company, have to be paid last. So a company will have creditors, they will have preference shareholders. So those have to be paid first before the owners of a company, the shareholder, are actually paid. So in a nutshell, that's what I meant they've got a right to the residual asset in the event that the company is wind up or it's being shut down in the proportion that they hold the shares, but they need to. Sometimes there may be nothing left after everyone has been paid, which means the shareholders will get nothing. So best paid, but they come last at the end of the queue after everyone has been paid because they're the owners of the company. You cannot pay yourself. Meanwhile, you've got other creditors who you owe money. That's what I was trying to explain.
Okay.
I hope that's helpful.
Yes. And then we have Emmanuel Chalwe, who says, how much due diligence should shareholders perform before investing? Then let me just combine that one with another one. We have also Emmanuel Kasanda. Emmanuel Kasanda is asking, he says, thank you for the presentation, Bruce. On litigation rights, you highlighted that directors owe fiduciary duties to their shareholders. What legal remedies are available under the Zambian company law when directors breach their fiduciary duties to the shareholders? Then there's another one which speaks to what share. Sorry, Mr. Bruce, I wanted to just add the third one so that you can answer the three. I'm saying I wanted to add the third one so that you can take the three questions at the same time, because these are the last questions that we have for the meeting.
Can I take the first two first? Can I take
All
the
right.
first two start?
Okay, sure. Go ahead.
The first, sorry, can you repeat the first one? I got the second one. What was the first one?
Okay, so the first one was how much due diligence should shareholders perform before investing? That's the first one. How much due diligence should shareholders perform before investing?
Well, you need to do as much DD as you can before investing, but I would advise that you also engage a licensed investment advisor or a broker who will help you with certain information to help you with your DD. Then regarding the course of action available to shareholders in the event that they sue the directors for breach of their fiduciary next. Not a lawyer, so I'm not an expert.
Okay. I don't know if we have anyone from our team, from the tech legal team, maybe to assist. Otherwise, we can move to the next question. Mr. Bruce, the last question is, what rights do what rights does a shareholder have in a public company that is delisting?
Sorry, Stella, I was front off. I was saying, is anyone from legal that can address that question?
Yes, I'm actually trying to get someone from the legal team to Fika. Okay, Fika to just assist us. Fika, are you on the call? Oh, okay, she can speak through my mic. So the question was speaking to the litigation rights. In the presentation, he did highlight that directors owe fiduciary duties to their shareholders. So what legal remedies are available under the Zambian company law when directors breach their fiduciary duties to the shareholders. So Chika will just assist with that.
Okay, good afternoon, everyone. So I think even the way the Company Act is structured, in as much as directors have quite a bit of autonomy, it still gives the court some leeway to come in where minority shareholders feel like some decisions that the directors have made are detrimental to the minority. So you can go to court, but the only thing is before you institute such proceedings, you need leave of court because the court is quite reluctant in coming into managerial decisions that a company makes. But where you can show that certain decisions that a board of directors is making is detrimental to the minority shareholders, the court can come in at that point. So yes, minority shareholders still have that option to take certain matters or certain decisions that the board makes to court, only that you might need the leave of court for you to institute such proceedings.
Okay, thank you so much, Chika. I hope that answers your question, Emmanuel Kasanda. Then the last question that we have, Mr. Bruce, is speaking to the rights of a shareholder in a company that is delisting. What rights does a shareholder have in a company that is delisting?
So before a company would delist, the shareholders who have to be consulted, there will be an extraordinary meeting or at the annual general meeting, and it will be voted on. So therefore, the shareholders will know exactly what has prompted the delisting, and what remedies will be available will also be availed to the shareholders at the same meeting. So shareholders will have a say before the company delists, so that they can protect their interest. So there will be some options available to the shareholders. I may decide to give notice to the shareholders, or I request for their approval to delist, of course, giving reason why the company has to delist. And the company also provide a solution. You can still remain a shareholder in the company, even though the company has delisted, but it doesn't change the fact that you're still a shareholder. Or if the other alternative is that if the company decides to delist, they may decide to buy back the shares from the existing shareholders and offer them a higher price, usually above the market price, to entice them to sell, so that the company can delist. And once they delist, they don't have the minority shareholders in there. So there's always some form of remedy.
Okay, that's good to know. Thank you so much, Mr. Bruce. That marks the end of our questions for today, and also the end of our town hall for today. Would like to thank each and every person that has joined the town hall the whole of 2025. The commission is very, very grateful, and we hope to get your feedback on the topics that we've shared in the previous town halls. Like I mentioned last month, I did mention that you can post or send us topics that you feel we need to emphasize on, or that you feel you need the commission to speak on. Please send those ones coming. Keep those ones coming. You can send them to our Facebook page, in the chat here, as well as to our emails. We will be able to address them and be able to structure our town hall topics for next year, so that we can tackle each and every topic that is burning in the minds of our investors. We value your time, and we value you, and we hope that you have a good festive period and a prosperous trade. Looking forward to seeing you in 2026. Thank you so much. Have a good day.
Thank you, Sally. Thank you, everyone.
To fall for a fake deal. Don't get caught. Before you send money or invest, make sure you're dealing with a licensed financial service provider. Protect your money. Stay alert. Be a smart investor. This message is brought to you by the Securities and Exchange Commission, protecting investors in the capital markets. Beware, scammers are getting smarter, and with mobile money and digital payments, it's easier than ever to fall for a fake deal. Don't get caught. Before you send money or invest, make sure you're dealing with a licensed financial service provider. Protect your money. Stay alert. Be a smart investor. This message is brought to you by the Securities and Exchange Commission, protecting investors in the capital markets.